Hi guys, hope you're doing well. Yeah, no makeup today. It's fine. Just get past it. Lori, my maiden name was Kelly, and my first name is Kathy. So you just said hi, Kathy and Kelly. Kelly, I am very glad you took some time off because I don't want you to get burnt out. But I have to tell you, it felt like I was missing my right hand the entire time. Like, you guys don't even know. You guys don't even know. Kelly is the only one that actually scared me one day, um, with something that she texted. Because so at the beginning, she was like the only one holding chat up. She was chatting and chatting and chatting. And then she said these words, and my heart dropped. And I thought, oh no, it's the worst thing that ever happened to me. Kelly said, I think I'm talking too much. I think I'm telling too many stories. I don't want to be annoying to anybody, so I'm just going to stop chatting. And like, I never beg people. I don't beg people to like subscribe, chat. Never. But I begged her, please, please, Kelly, please do not stop chatting. Please, please. And it was really scary. I thought she was going to stop chatting, and I thought, oh my gosh, no, not Kelly. And since way back, like, Kelly's always there, always holding up chat, always. And she took a couple days off, and I'm telling you, it felt like I was missing my right hand. I'm serious. I felt like it just wasn't right. But I don't want um you to feel like this is a job and you always have to be here. So I'm very glad you took some time off. Very, very glad. 'Cause I want you to like coming here and not feel like you have to be here. Ugh, ugh, ugh. No, but I missed you very much, Kelly. Really, really much. Okay, Kelly's back. I didn't say anything to piss her off. Whew, whew. I don't want to piss off Kelly ever, ever. So, Maiko, we're gonna spend the day with our judge today. We're gonna have Judge Fleischer's. We're gonna do the rest of Friday. Um, it's just so nice that Kelly's in chat, guys. I'm so happy. We're gonna finish with Judge Fleischer, but the first part, me and Michael are just gonna chill and relax and watch Judge Reese because we love him. And his voice just like wraps around us and makes us feel good. He has some great sayings today. Nobody freaks out or anything, but I'm gonna start with someone else. I'm gonna start with Colorado because I just think this crime is a little unusual. So, and we're all about the unusualness. And I probably wouldn't even have gotten it, even though this crime was a little unusual. I probably wouldn't even have thought twice about this clip, except for the way that she's dressed in court. Now, I understand these suits are not made for um, you know, I don't know. They're made to protect this inmate. I understand that. But I've never seen someone wear this just like this. So this is probably why I got this. Let's go to Colorado. Oh no, if Raven's here, I hope I got the right state because Raven doesn't like it when I get the wrong state, even when I know I'm right. There she is right here. She looks like I just want to help her. Hi, Mary. Don't rush. It's fine. As long as you're here. Hi, Elvis. MDJ, I hope you're doing good today.
Court will recall People versus Bernadette Weaver, 24 CR 1912. Ms. Weaver, are you now or have you ever been in the U.S. military?
No, sir.
Did you understand your rights in the advisement?
Yeah, I understand, yeah.
You're here on allegations of first degree assault and child abuse, possession of a controlled.
If I ever showed CJ on my channel, you'd never find me. I would be dead, 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 dead.
Substance. Do you understand the nature of the allegations?
I don't understand the possession of a controlled substance or the child abuse. I'm not real sure.
Okay. I don't want you to take this as an invitation to respond. As a courtesy to you, I will.
Guys and girls, keep that in your back pocket. I don't want you to take this as an invitation to respond, but I want to say that to somebody so bad.
Give you the thumbnail, but sometimes people think then that they're being asked to respond. You have the right to remain silent. Your attorney does not want you to make any statements. As I understand, the allegations are that there was an altercation when you left in the vehicle.
The better to eat you with, my dear.
Someone was sort of caught up, run over, partially run over, and that a child was left there barefoot on the side of the road.
She was driving her car and someone was still hanging on to it while she was driving away. Someone was still hanging onto her car while she was driving away. Another thing we should put in our bucket.
Collection is then that the allegation was that there was a purse found believed to belong to you and that it had controlled substances in it. Based on those potential charges, I'll issue the protection order. Do not harass, molest, intimidate, retaliate against, or tamper with any victim or witness. I will require that you have no contact with Tangela or Arian. And those full names will be put in there. My handwriting isn't very good this afternoon. Looks like Tangela Ferris and Ariana Pinner. So do not harass, molest, intimidate, retaliate against, or tamper with any victim or witness. Vacate the home of the victim. Stay away from the home of the victims in any other location the victims are likely to be found. Refrain from contacting or directly or indirectly communicating with the victim or the victims. And then I will hear bond argument. First of all, any VRA record, Ms. O'Hara?
Yes, Your Honor, we've had contact with the adult victim. She's requesting a high bond in the no contact order for her and the child.
I don't know who the child was, if it was her child or not, but apparently while she was driving away with someone on her car, the child was left barefoot, which makes me think I could get my mom arrested because I was always barefoot as a child. Always. We never wore shoes. In Pennsylvania, I mean, I walked in the snow with no shoes on. It was fine. We were fine. But this is a service announcement. If you're going to partially run over someone and drag them down the street and leave a child with no shoes on, don't leave your purse behind with meth in it.
Okay, and then bond argument, Ms. O'Hara?
Your Honor, with respect to the people's argument, the defendant wasn't available for pretrial, so we don't really have any verified information. I would note from the affidavit, it appears she has no ties to Colorado, and they were simply here to obtain some items, and then they were going back to Michigan. So the people do have concerns about whether the defendant will.
That explains it, guys. She's from Michigan.
Show up for court dates. That being said, I don't necessarily have anything to say that she has a history of FTAing or anything. It's just there's no ties here. I would note she does have a relatively small history out of the state of Michigan for a misdemeanor assault.
Sorry, Mary. You have to go. You can't be here anymore. You have to close your eyes. I don't make the rules.
Misdemeanor fleeing and then resisting and obstructing. Most of those occurred quite some time ago. Obviously, the allegations here are extremely serious. A first-degree assault where the victim was, in essence, somehow hurt by the vehicle. The affidavit made it seem like she was probably run over when she was hanging on. And then obviously the risk that what the child victim was facing with respect to being left out in the cold. The people do believe that a $25,000 cash or surety bond is most appropriate. I am requesting pretrial supervision, and we don't know anything about the defendant. So I guess I'm hard pressed to say she shouldn't leave the state of Colorado at this point in time. But as I said, those are my concerns.
Thank you. Mr. Trujillo.
Thank you, Judge. We're asking the court to issue bond no more than 10,000 cash or surety. I do understand that the allegations here involve a class 3 felony and that these allegations are very serious with a high charge. The possible penalties, of course, especially including SBI. I do realize the exposure that she has with the possible penalties as well. However, I don't believe that Ms. Weaver is a flight risk. I understand that Ms. O'Hara and the court don't have a whole lot of information on Ms. Weaver, but my understanding is that the parties do know each other from previous relationships.
Mary, I can tell you this doesn't fall off. We're not going to see anything PG-13 in here. Nope. And all the rest of the defendants in Judge Reese's courtroom, all you see is the back of their head. So you have no reason to watch anymore. You've seen enough. You can just listen.
And that was kind of the basis of the contact, was dealing with a late family member. Miss Weaver does live in Michigan. She holds a job there. Her whole entire family is there. So I would be asking, and it doesn't sound like there's an objection from the prosecution for a bond condition that she be able to leave the state. I think she understands the gravity of these offenses. My understanding is that she also has an injured leg. It's a little bit unclear of when this had happened, but she's currently on crutches. So her mobility is also very limited. But I don't believe her returning to Michigan while fighting these allegations is something that should be counted against her, especially that is the area where she has a lot of support in light of her medical issues. She has very limited criminal history, as noted on the pretrial services bail report. I don't have any information to suggest that there's anything else. I am seeing that the last offense is from 2012, which was a misdemeanor. And of course, these are all in Michigan, and it's unclear whether or not there were convictions here. I know Ms. Weaver understands the gravity of these allegations. I think the court can kind of see her emotions now. So we're asking that the court set bond no more than 10,000 cash or surety.
All right, and the court does take into account, and obviously serious allegations, the court takes into that possible penalties as well, the prior criminal history and the totality of the circumstances. The court is going to temper the number somewhat based on non-monetary conditions. Court will set the bond $15,000 cash or surety with the condition that you appear at all future court dates, report to pretrial services within 24 hours thereafter on a schedule, participate in and pay for substance use monitoring, do not possess or control drugs or alcohol except for medical marijuana, prescription medications, comply with the mandatory protection order, do not possess or attempt to possess or control firearms, ammunition, or any sort of weapons, do not violate state, federal, and municipal laws, and you can leave the state, but only with written consent after coordinating it with pretrial services so that they can help you set it up there. Not intending to keep you here, but I want to make sure that they are able to keep you accountable. The return of charges November 5th at 3:30, in custody, out of custody, November 12th at 3:30. Thank you. You'll be in front of the district court. Good luck.
Man, we're spitting all kinds of wisdom in this chat today. Fozzie, reread what she said. Stay away from crazy. Fozzie let me hold his beer the other day and it was empty. Jerk. Or maybe it was empty when I gave it back. I don't know. One of those two things happened. Okay. Now we're going to go to this one. I hope the sound is okay. Sugar.
How are you, Mr. Castillo?
Yes, sir.
And you're Mr. Fussell.
Yes, sir.
And I'm told that each of you is here today with the intention of entering a plea of guilty to certain charges against you. Before I can decide whether or not to accept your plea, I must first determine what...
She was wearing exactly what she needed to wear to get onto YouTube. Now you know, guys. If you want to be YouTube famous, wear that just like that.
Whether you're doing this knowingly, intelligently, and voluntarily. That is, do you know and understand what you're doing? So I'm going to be asking you a number of questions. Now, if I ask you a question and you answer the question, I'm going to assume that you understood the question. So if you don't understand my question, please stop me and tell me. Please raise your right hand and you swear the testimony you're about to give in the case now and hear me the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes, sir.
All right, you put your hands down now. Each time I ask a question, Mr. Castillo, you always answer first. Mr. Fussell, you wait until you hear him answer, then you answer.
If you see a short come up on your feed that says "Happy Birthday, Victoria," just click on it and write in comments "Happy Birthday, Victoria," because it was Victoria's birthday yesterday. The Victoria from Judge Fleischer's courtroom, Victoria. And hey, 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 I am elite in my job. I'm elite. You always have beer, always. Because I don't wait till your beer empties to get you another beer. Once there's so here's how you sell a lot of beer, guys. If you wait, all right, I think we're back. I'm going to wait a second. I'm up to my ears. I got a mesh going on and everything. Hold on. I gotta look at the stream to see if you can. Yeah, okay, you can hear me. We're good. We're good. Anyway, if you wait till a person drinks their beer all gone, they've had time to think through. I guess I don't really need another one. But if their beer still has like 3 fingers in it, maybe 4 fingers in it, and you ask them if they're ready for another one, it's like they have to. It's like they're scared they're not gonna get another one when their beer's gone. Their beer is almost gone. They're scared they're gonna have to wait once their beer is gone to get another one. So they're like always, "Yes, please bring me this one, bring me that one." So if you wanna sell beer, never, ever, ever wait till they finish their beer to get them another beer. Always get them another beer when they have 3 to 4 fingers. Psychology.
And that way I have a good, clear recording of everything that goes on here today. How old are you?
32, sir. 29.
And how far did you get in school?
I have a GED, sir. College.
Are you able to read, write, and understand the English language?
Yes, sir. Yes, sir.
There's a sworn statement here that has a number of rights listed on it, and then there's answers on the left-hand side indicating that you understood those rights. Are you able to read and understand those rights, or have someone explain them to you so that you can understand them?
Yes, sir.
And as you provide the answers there on the left-hand side indicating that you...
This is part 1. It's a short. Just say happy birthday, Victoria. She will love it. She deserves a good happy birthday comment. And this is Fozzie's. Fozzie created a short in response to that short, which is unbelievably great. Hi, Nan. You can also, or say happy birthday to Victoria here. No, I always have ranch in my back pocket too. You know the ranch? There you go. Psh. Here's another one. Psh. Oh, blue cheese. There you go. Yep. All right. Come on, Judge. Make us feel better.
You understood those rights?
Yes, sir. Yes, sir.
And all the answers you provided true and correct?
Yes, sir. Yes, sir.
And is that your signature on that form swearing before the deputy clerk that those answers...
All right. Since you're not the first person who asked this question, it's Victoria's birthday. And when Victoria's at work, what she does all day is the same thing. Page 13, Williams, come on up. Page 12, Davis, come on up. Page 10, Fozzie, come on up. So that's what I did at the bar. I had them call out. So actually, Peters are one of my best couple of customers. They're the people that I gave the beers to, and she's the one who took over calling out at the end when Jessica gave up because I wasn't giving clear instructions. Yep. Jessica gave up making that video with me because I was not giving her clear instructions, she said. So, um, I'm like, guys, you gotta let me video you. I have to. So they were Victoria. And they're like, that's what the page means. So Fozzie was, he wrote that on there, what Victoria says. He wrote, I can't remember, was it page 3? Page 3, Fozzie, and was holding up his beer, just like Victoria's calling out. Page 3, Fozzie. And then he changed his name to Peters because they got their beer. 8, page 8, page 3. I knew it was something. I knew I was close. So that's what page means. Yeah. Yeah, she didn't think I was going to use that, but joke's on her. She did not want to be in the video, but she put it on my phone.
Is or true and correct?
Yes, sir. Yes, sir.
Is there anything on there you did not understand?
No, sir. No, sir.
Have you ever been diagnosed or treated for any mental illness?
No, sir. No, sir.
Are you now under the influence of any alcohol, drugs, narcotics, or other medications that would have an effect on your ability to know and understand what's going on here today?
No, sir. No, sir.
Now, I understand there's been certain negotiations between you and your lawyer in the district attorney's office, and you expect the district attorney to make a recommendation in your case. Do you understand I do not have to accept that recommendation, but if I do not accept it, I'll give you a chance to withdraw your plea?
Yes, sir. Yes, sir.
Other than them agreeing to make a recommendation in your case, has anybody promised you anything to get you to plead guilty?
No, sir. No, sir.
Anybody threatened you in any way or used any force or any violence against you?
It's Michael's favorite number when she calls it out, and I definitely used page 13. I think that was the first one, page 13.
To get you to plead guilty?
No, sir. No, sir.
And Mr. Castillo, you understand you're charged with possession of a firearm by a convicted felon?
Yes, sir.
He probably still had a stroke.
And you understand that if you were to be convicted of that offense, you could be sentenced to from 1 to 10 years in the penitentiary?
Yes, sir.
And Mr. Fussell, you understand you're charged with exploitation of an elderly person,
Diffendorfer. You don't have any Diffendorfers there? They're all over the place in Lancaster.
terroristic threats, and battery, family violence.
Yes, sir.
And if you were to be convicted of those offenses, you could be sentenced to from 1 to 25 years plus 12 months in the penitentiary.
Yes, sir.
Do you have any questions you would like to ask me about the charges against you or the maximum punishment you could receive?
No, sir. No, sir.
Hey, Mr. Fussell, they tell me you are eligible for first offender treatment. Is that correct?
Yes, sir.
With regard to that, I need to advise you that if a first offender probationer violates the terms of his probation and the court then enters an adjudication of guilt, the court may then impose any sentence permitted by law for the offense the probationer has then been found guilty of committing. Therefore, the probation revocation hearing and upon an adjudication of guilty, a first offender probationer may be resentenced to a sentence that is greater than that imposed at the entry of the original plea. But of course, you get credit for whatever time you've already served on probation against that new sentence. Now, you think you understand that?
Yes, sir.
Understanding that, do you still desire to be considered for first offender treatment?
Yes, sir.
You are advised that if you're not a citizen of the United States, a plea of guilty will have an impact on your immigration status. Do you understand?
Yes, sir. Yes, sir.
All right. Do you understand that you have the right to plead not guilty and demand a jury trial, in which case the state would be required to prove your guilt of each element of the crime charged against you beyond a reasonable doubt?
Yes, sir.
If you plead not guilty, the Constitution guarantees you at trial, among other possible rights, the following: the right to a speedy and public trial by jury, the presumption of innocence, the right to confront and question the witnesses against you, the right to subpoena witnesses and evidence in your favor, and a right to present those witnesses and that evidence during the trial. The right to the assistance of a lawyer during the trial, the right to testify if you would like to, but you would also have the right against self-incrimination. That is, no one could make you testify. And if you chose to not testify, that fact could not be used against you or held against you in any way. You would testify or not, and you personally would make that decision.
Allie only told me the name of that bar 7, 8, 12 times, so there's no way I can remember what it's called. Is it Coyote Ugly? I know it's Coyote something.
And you understand that by pleading not guilty or remaining silent and not entering a plea at all, you would obtain a jury trial with all of these rights?
Yes, sir. Yes, sir.
And do you understand that if you plead guilty, as you're doing right now, you give up all of these rights?
Yes, sir. Yes, sir.
Tell the facts and circumstances surrounding the charges against Mr. Castillo, please, and the recommendation.
Yes, Your Honor. On May 17th of 2023, law enforcement responded to 205 Bud Jordan Road in Vidalia, Toombs County, Georgia for a welfare check. I believe it was the wife or girlfriend, paramour of the defendant who called law enforcement. They had been in an argument, the wife/girlfriend and the defendant. The female who called told law enforcement that the defendant was a convicted felon and that he had a firearm in the car. The defendant told law enforcement, yes, I do have a firearm in the car, and yes, I am a convicted felon. The law enforcement then did look in the car, and there was a shotgun found in the vehicle. The state's recommendation is 10 years probation, and there's also a special condition for the Family Violence Intervention Program, as well as special conditions 2, 10, 11, 14 being the family violence, 15, 16, 25, 32, and 34, that being employment. And 50 is the, yeah, as well as a $50 fine, Your Honor.
What are his priors?
He has one prior in 2011, and I believe Mr. Hart told me that he did not use his first offender, although he could have. Apparently, he was not informed of that option, or else he would have pled first offender and would have completed. He's been in no other trouble since then. It's a
What was that for?
criminal damage in the second, theft by taking burglary in Tattnall County, September of 2011.
I think I see the wheels turning, Your Honor. About the issue here is he had no issues at all, no revocations, no late payments on the probation he was on. He's the sole provider for 4 people. His wife stays at home mom, takes care of his 2 kids, and then 2 kids that were not his. He makes $32 an hour working. That's a lot of money, but it's still tough on that to provide for 5 people altogether. So based off of his lack of history, and also his employer was, if we didn't have it negotiated, was going to come and testify today. He's done everything right. He shouldn't have had a shotgun in the car. But other than this, and since that issue, he's been exemplary. And I'm impressed that after having a felony conviction on your record, he's making $32 an hour.
Given that, I'm just concerned about having a prior and possession of a firearm by a convicted felon, and we're talking straight probation. That's a little bit light for what we usually do. Now, granted, he wasn't using it in a crime. I got that, and that's a big difference. What kind of shotgun are we talking about? You don't have any idea, probably.
Stoger P300.
I love that part. What kind of shotgun? You probably don't know.
Stoger P300.
Okay.
I think that's a 3.
Yeah.
Could be
This is just standard shotgun.
That's a 3. You're right.
Okay. Wasn't sawed off or anything like that.
No, Your Honor. It would have been charged that way. I'm positive.
Yeah. Ms. Castillo, you knew you were a convicted felon.
Yes, sir.
You knew you couldn't have a firearm.
Yes, sir.
What was your purpose for having a firearm?
It wasn't mine. It was just in my possession, and I was leaving, and it was in the vehicle I was in, and the vehicle that I was driving.
But you knew that that's a violation to have it in your possession, whether it's yours or not. You understood that.
Yes, sir.
You don't hunt. I'm assuming you don't have a right to have a firearm. You can't hunt. I guess you could hunt with a bow and arrow, but strangely not with a crossbow. Crossbow, for some reason, considered a firearm. Where do you work?
I'm a plumber for heat and plumbing.
Okay. All right, Ms. Castillo, I'm gonna accept this recommendation. As you can tell, I'm a little bit reluctant, so you don't want to come back. You understand what I'm saying?
Yes, sir.
You're being given not the biggest break in the world. It's a little bit of a break. It's not a big break. I understand that. But most of the time, possession of a firearm by a convicted felon is going to get some time to spend somewhere not at home. So you need to be aware. If you get in somebody else's car, make sure there's no firearm in the car. Your friend wants you to take a firearm from one place to another place. You say, I'm sorry, I can't do that. I can't even have it in my car. I can't have it in my house. I can't have it in my bedroom and nightstand. I can't have one anywhere around me. I can't even pick up one and look at it. So I tell the story all the time. I had a client when I was practicing law that was a convicted felon, and somebody was sitting there in the living room and they were all talking about grandpa, and somebody said, well, whatever happened to grandpa's shotgun? And so I said, oh, it's over here in the closet. And they went and got it out of the closet and handed it to my client. He was looking at it, and his probation officer walked up on the front porch and looked in the window. There he stood with a firearm in his hand. It's just that hard.
Yes, sir.
Okay. You heard that recommendation. Is that the recommendation that you've agreed to and the one that you expected them to make?
Yes, sir.
You listen to this part too. Part of the recommendation is you'll be subject to Fourth Amendment waiver. That is, you give up your Fourth Amendment right against search and seizure while you're under this sentence. And you have to agree that as a special condition of probation, you shall submit to a search of your person or property any time of the day or night, with or without your consent, and with or without a search warrant, whenever you are requested to do so by your probation officer or any law enforcement officer. If anything is found in that search, it may then be taken and used against you in any further court proceedings. Now, do you understand that?
Yes, sir.
And do you agree to that?
Yes, sir.
You understand that?
Yes, sir.
You agree to that? That's part of your sentence too. Okay. Getting back now individually to Ms. Castillo, do you now freely and voluntarily admit your guilt to the charge against you, admit the facts as stated by the prosecuting attorney, including her description of your conduct that forms the basis of these charges, and do you enter your plea of guilty to the charges against you?
Yes, sir.
You're here today with your attorney, Mr. Hart. Are you satisfied with the services he has rendered to you in this case?
Yes, sir.
Is there anything else you'd like to say?
Yes, sir.
Mr. Hart, you heard the recommendation. Is that the one to which you and your client have agreed?
It is, Your Honor.
You satisfied that he understands all of his rights?
Yes, Your Honor.
Is there anything else you'd like to say?
Thank you, Your Honor.
All right, Mr. Castillo, the court finds that you understand the nature of the charges against you and the consequence of your guilty plea, that there is a factual basis for the guilty plea, that you decided knowingly, intelligently, and voluntarily to plead guilty. The court will therefore accept your guilty plea. And I am going to accept the recommendation of the court, of the DA's office. It'll be, and your lawyer, the negotiated plea, be a 10-year sentence.
Our Walmart still has guns, but only like guns for hunting. They don't sell handguns or anything like that. They just in the hunting section.
I allow you to serve out on probation, subject to the special conditions of probation outlined on attachment A to your plea sheet, which has been signed by you. There'll be also a $50 fine. Now that will be the judgment and the sentence of the court unless you'd like to withdraw your plea. Would you like to withdraw your plea? All right, now this is, I don't get myself confused now. Obviously he has a prior, so this is the type A sentence.
Oh my gosh, that would be so cool if she came to America and shot a few guns. Oh man, yeah. Her dad would not like that. No, she can't do it.
So it has to be the 10 years, of course. That will be the judgment and the sentence of the court unless you'd like to withdraw your plea. Would you like to withdraw your plea?
Yes, sir.
All right. If this is a felony conviction, you'd have a period of 4 years within which to petition the appropriate court for habeas corpus relief. If you'd like to know more about habeas corpus relief, I'm sure Mr. Hart will be glad to explain that to you. Thank you, sir. Tell me the facts and circumstances surrounding the charges against Mr. Fussell, please, ma'am, and the recommendation.
Yes, Your Honor. On August the 17th of 2023, officers responded to 123 Old Peastraw Circle in Vidalia, Toombs County, Georgia. The defendant's ex-boyfriend had called 911 because the defendant's mother, the listed victim in this case, was noticeably physically injured. The
boyfriend stated that he had just gotten home and quote, "She's messed up bad." The defendant was intoxicated.
Way too late.
The responding deputy took photos of her face. Her eyes were almost swollen shut. The the mom actually made statements to law enforcement that her son had physically assaulted her. She wasn't sure why. Quote, "He beat the hell out of me," is what she told the deputies at the time. She refused medical treatment, stated that this wasn't the first time that this had occurred. The ex-boyfriend was a trucker and had a ring or some type of camera inside of the home. And there were camera footage of him threatening to kill her. And the attack was around 4 p.m. The ex-boyfriend showed up around 9 and was concerned that mom was grievously injured and had called law enforcement at that time. In contemplation of, the victim in this case actually passed away in January of this year, not of natural causes, not any relation to this, or that would be a completely different charge. The state's recommendation in contemplation of that is a $1,000 fine. Count 1 will be null prost. Count 2 is 5 years probation, subject to the special conditions of probation we're about to talk about. Count 3 is 12 months probated concurrent with count 1. He is eligible for first offender. The special conditions of probation, numbers 2, 10, 11, 14, 15. I would ask that 16 be checked because 16 actually encompasses anger management that we have at the very bottom. It's just a different checkbox on the sentence.
Any objection to that?
No, sir, Your Honor.
All right.
18, 25, 32, and 34. And of course, the state would certainly ask Your Honor to warn Mr. Fussell regarding any sort of family violence act in the future. We certainly hope that the Family Violence Intervention Program assists with that, but any further family violence battery of any person would be a felony.
All right, Mr. Fussell, you heard that recommendation. Is that the recommendation you expected her to make and the one to which you have agreed?
Yes, sir.
Do you now freely and voluntarily admit your guilt of the charges against you, admit the facts that
What? What? That's awesome. I am so proud of you. I have a list. Can I give you my list, please? This is like the perfect crime situation because no one would guess it's you.
stated by the prosecuting attorney, including her description of your conduct upon the basis of these charges, then do you enter your plea of guilty to these charges against you?
Yes, sir.
Are you here today with your attorney, Mr. Hart? Are you satisfied with the services that he has rendered to you in this case?
Yes, sir.
Anything else you'd like to say?
No, sir.
Mr. Hart, you heard the recommendation. Is that the one to which you and your client have agreed?
It is, Your Honor.
Satisfied that he understands all of his rights?
I am, Your Honor.
Anything else you'd like to say?
Just for it not to be as too bitter on Your Honor's palate, also the video that the ring camera was supposed to happen, the deputies weren't able to recover that. That's
Another part of the negotiated plea, yeah.
Yes, sir.
I figured that. All right, Mr. Fussell, the court found that you understand the nature of the charges against you and the consequence of your guilty plea, that there is a factual basis for the guilty plea, that you have decided knowingly, intelligently, and voluntarily to plead guilty. The court will therefore accept your guilty plea. And I will accept the recommendation of the judge and the sentence of the court. To be count 1 will be non-pros, count 2 will be a 5-year sentence. I later serve it on probation, subject to the special conditions of probation outlined on attachment A to your plea sheet, which has been reviewed and signed by you. And there will be a $1,000 fine. Count 3 will be 12 months probation to be concurrent, served on probation, to be concurrent with count
Savage. That's savage.
2. That will be the judge and the sentence of the court unless you'd like to withdraw your plea. Would you like to withdraw your plea?
No, sir.
Now, Mr. Fussell, part of this is you will undergo the Family Violence Intervention Program. That is, you'll take these courses and learn how to deal with family disruptions without becoming violent. You'll also be required to participate in what they call anger management program, which is a separate program, but with a similar kind of thing. It's very, very important that you get yourself under control. Now, if alcohol and or drugs are a part of the problem, and
No. Yes.
yeah, okay, then you need to get that under control.
Yes.
my daddy used to always say there's two kinds of liquor. There's loving liquor and fighting liquor. Some people, when they drink liquor, they want to be sweet and nice and love folks. Other folks drink liquor, they want to fight. Apparently,
Loving liquor. Loving liquor.
you're one of them that wants to fight. So you got to quit the drinking.
Yes, sir.
Quit the alcohol. Part of this probation is you'll have no alcohol, no drugs.
Yes, sir.
So get that under control, okay?
Your Honor, so in light of that, I didn't check 16. I assume the state would ask to check 16.
16, yeah, she did, and I checked it.
Oh, my bad.
That's what I
Okay.
wanted to check.
That's right.
Yeah, if her uncle showed what we thought she was talking about, Kelly would laugh at him. Which I think is amazing. Yeah.
Yeah, I did. But you got to get that under control. And as she pointed out, you had a previous battery family violence that was dismissed. If that one had not been dismissed, and if you've been convicted of that, then this one would be a felony. If you get another battery family violence,
Georgia.
that will be a felony, because once you've had the misdemeanor, then you've got that on your record, then there'll be a felony the next time.
Yes, sir.
You understand that?
Yes, sir.
All right. All right. Thank you very much. Let's see, no confinement is the first offender sentence, so okay.
Thank you, Your Honor.
Dude, he destroyed his mom, and now he's in court for it, and she passed away since then. What? Could you imagine sitting in court for destroying your mom, knowing like she's not around anymore? This was like the worst thing you've ever done to her. And once people pass, you think about the greatest things, and now this. Whew, man, oh man. We got one more along the same vein. But I'm not gonna lie, when I was recording this piece, I fell asleep. So I have to remember where to stop it. And it'll be all right. Don't worry about it. Don't worry about it. That sounds like it's going to be a little bit loud. So let's go ahead and fix it quick. Same judge, different county. He does cases, then he gets in his car and he drives over to the next county and does cases and gets in his car and drives over to the next county, and they come with him. Not everybody, but I'm just going to bump it down a pinch. If I have to bump it back up again, I can, but at least I think, listen, if I'm too loud, Mary's going to look at the screen and then she's going to be in a lot of pain. So we got to be careful.
Yes, ma'am. And probation, do y'all have a termination thing on Mr. Nettles?
And I think we lose his mic for a minute or two, maybe not a full minute, but don't worry, it comes right back.
And what's the report? Okay. Is he here? You got the report? No, Mr. Nettles? Mr. Nettles, you'll wait right there, please, sir. Let me do this right quick, and then we'll get to you.
Your Honor, this is Martin Chaplain Barrett, position number 14 on page 4, 24 CR 003.
Charged with fleeing and attempting to elude and driving under the influence.
Yes.
How many syllables can she make the word for and 3?
Your Honor, Mr. Barrett is a type C recidivist. I believe the offer is 10 years without parole on count 1, followed by 12 months on count 2, if I read the plea sheet correctly earlier. And Mr. Barrett has rejected that and is announcing ready for trial.
So what's he facing if he goes to trial?
10 years without parole plus 12 months.
So they're offering him
10, I mean, it's got to be 10 years because it's felony fleeing, and he's an A for those purposes, and then he's a type C, so it's 10
under
without.
that statute that you can't probate or
Correct. It cannot be probated, stayed, deferred. It cannot be reduced to another charge. It can't be run concurrent
So
with
he's got
anything.
absolutely nothing to lose by going to trial.
That's correct, Your Honor.
That's what they've created. All right, well, you've already got your notice of when to report for trial.
Yes, sir.
So we'll see you back here for trial.
Thank you.
Does anybody else have that same problem? Because I can turn my microphone up. But every time I turn my microphone up, I get people saying that I'm blasting their ears out, which is the last thing I want to do. So this guy, while I'm waiting for answers, this guy, the prosecutor gave him, the plea is like 10 years. And if he goes to jail, he'll get 10 years. So it doesn't matter. He's going to trial. He's going to trial because there's no good taking the plea will do him. None. I mean, sure, it's probably not going to go great in trial either, but well, nobody else said anything. They didn't say it's good, bad, or ugly. So I'll just wait.
Okay, let me make sure we information, okay? Don't leave just.
All right, now who we got here at the table? That's Mr. Taylor. All right, and Mr. Rodriguez, and then Ms. Lovett.
Oh, the termination. Wait, who? Oh, they're ready for trial? Okay.
Kinky.
Yes.
You just pull out the police sheet and give you the case files back. How about that?
Yeah, sorry. No, I think I had that later on when we ran.
That'll keep me from having all that.
What were you drinking? What was your drink?
Lord, you got me enough stuff to sign here.
Lauren, leave the judge alone.
I'm gonna do it. Thank you. I'll sign this stuff later. Yeah.
State's ready. Did we do the termination?
Yes. You got the paperwork on him. Wayne Bell. Before I can decide whether or not to accept your plea, I must first determine whether you're doing this knowingly, intelligently, and voluntarily. That is, do you know and understand what you're doing? So I'm going to be asking you a number of questions. If I ask you a question and you answer the question, I'm going to assume that you understood the question. So if you do not understand my question, please stop me and tell me. Now, please raise your right hand. The use for the testimony you're about to give in the case now in Hig be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Yes, sir.
Put that microphone up closer to you so the court.
Yes, sir.
Yeah, all right. Thank you, ma'am. Just hold it up there. You put your hand down now. Tell me, how old are you?
38. 38.
38?
Yes,
Okay.
sir.
I'm 33.
45.
How far did you get in school?
9th grade.
Took a little bit of college.
College.
All right. Are you able to read, write, and understand the English language?
Yes.
Yes, sir.
Yes.
There's a sworn statement here that has a number of rights listed on it, and then a number of answers on the left-hand side indicating that you understood those rights. Were you able to read and understand those rights, or have someone explain them to you so that you can understand them?
Yes, sir.
Yes, sir.
Yes.
And did you provide the answers to those out there indicating that you understood those rights?
Yes, sir.
Yes, sir.
Yes.
And are the answers you gave true and correct?
Yes,
Yes, sir.
Yes.
Yes.
Sir. Is that your signature on that form swearing before the clerk that those answers are true and correct?
Yes, sir.
Yes, sir.
Yes.
Was there anything on there you did not understand?
No, sir.
No, sir.
No, sir.
Have you ever been diagnosed or treated for any mental illness?
No, sir.
No, sir.
I've been treated for
All right. For what?
depression, anxiety.
Okay. Are you on medication for that?
Not currently, no.
Do you need to be on medication for that to be able to know and understand what's going on around you and to handle your personal matters?
No, sir.
All right.
Not.
All right. Now, the next question is going to be a little tricky when I get to you, but are you now under the influence of any alcohol, drugs, narcotics, or other medication that would affect your ability to know and understand what's going on here today?
No, sir.
No, sir. Now, Ms. Lovett, I understand you tested positive for cocaine.
I do not have an echo. I do not hear an echo. There's no echo here at all. At all. Hold on. Let's try. I'm just going to bump this around just a little bit to see if.
Yes, sir.
The lawyer tells me, however, that she's met with you and she's talked with you and she's convinced that you're mentally.
Oh, for crying out loud, you got me. I thought there was a problem with my sound. I'm an idiot. Listen, it's 5:22 in the morning. It's too early for my brain cells to be working. Yes, there are 3 defendants.
Competent here today, not sufficiently under the influence of any drug or narcotic to affect your ability to know and understand what's going on here today. Is that, I know you've worked with her some more during the lunch hour, Ms. Payne. Is that still correct?
Yes, Your Honor, it still stands.
Right, now, Ms. Lovett, you know that you're fixing to enter into a sentence here, and it's going to require you to get treatment. It's going to require you to get clean and sober. Do you understand that?
I do. Yes, sir.
Now, what they're recommending, are you employed?
Gainfully, I've been with the same company for 11 years. I've also picked up some part-time locally here since I've transitioned here. The small business here. So yes.
See, ordinarily I would be talking about inpatient rehab, but of course that would interfere with your employment.
Yes.
But the question becomes whether or not you are going to be able to deal with this on an outpatient basis and give up those bad habits. Now, you think you're going to be able to handle that?
Yes, sir. If I can make a statement.
Yeah.
Yeah. I transitioned here from an area I did have support in some ways medically and activities, athletics. I was involved in adult athletics and coaching youth. And coming here, it's been.
What is adult athletics? I want to know. Should I have cut this part out? Did I cross the PG line?
Difficult.
Sure.
My elderly parent, the resources aren't there. So in no way am I using that as the only excuse or an excuse, but I understand I need the assistance and I've kept my job over these years and will continue to, and I do need that support.
Okay. Now, if you understand now, we're going to be monitoring you and testing you, and if you continue to test positive, then you're going to have to go into a long-term treatment program, and I think RSAT is a locked-up 9-month treatment program.
Yeah.
I don't want you to lose your job. I don't want to take away from that, but I do want to get you straightened out, and if that's what I have to do that, then that's what I'll end up doing. You understand that?
I do understand.
But she does see, I wanted to enter into that conversation with her at this stage, and she does appear to know and understand what's going on here today. She is corresponding appropriately. It does not appear to me to be under the influence of anything to the degree that would affect her ability to know and understand what's going on here today, so I'll make that a finding. Hold on a minute, let me change what I'm doing here a little bit.
All right. Judges can do anything.
understand there's been certain plea negotiations between you and your lawyer in the district attorney's office, and you expect the district attorney to make a recommendation in your case. Do you understand I do not have to accept that recommendation, but if I do not accept it, I'll give you a chance to withdraw your plea?
Yes, sir.
Yes, sir.
Yes, sir.
All right. Other than them agreeing to make a recommendation in your case, has anybody promised you anything to get you to plead guilty?
No, sir.
No, sir.
No, sir.
Anybody threatened you in any way or used any force or any violence against you to get you to plead guilty?
No, sir.
No, sir.
No, sir.
All right. And Mr. Taylor, you understand you're charged with terroristic threats and battery family violence?
Yes, sir.
You understand that if you were to be convicted of those offenses, you could be sentenced to from 1 to 5 years plus 12 months in the penitentiary?
Yes, sir.
And Mr. Rodriguez, you understand you're charged with aggravated battery, 2 counts and 1 count of battery family violence?
Yes, sir.
You understand that if you were to be convicted of those offenses, you could be sentenced to from 1 to 40 years plus 12 months in the penitentiary?
Yes, sir.
All the cool kids do 3 at a time.
And Ms. Lovett, you understand you're charged with possession of cocaine?
Yes, sir.
You understand that if you were to be convicted of that offense, you could be sentenced to from 1 to 3 years in the penitentiary?
Yes.
Do you have any questions you would like to ask me about the charges against you or the maximum punishment you could receive?
No, sir.
No.
No, sir.
Now, Mr. Rodriguez is seeking first offender treatment. Is that right, Mr. Rodriguez?
Yes, sir.
Do you have any prior convictions anywhere?
No, sir.
All right, I need to explain to you that if you are under the first offender act and then you violate the terms of your probation and the court then brings you back and enters an adjudication of guilt, the court may then impose any sentence permitted by law for the offense that you have then been found guilty of.
I am sure he gets grumpy if he misses lunch. I am positive. I would not want to be in the court if this judge misses lunch.
Admitting, therefore, the probation revocation hearing and upon an adjudication of guilty, you could be resentenced to a sentence that is greater than the one entered here today. Now, do you think you understand that?
Yes, sir.
Understanding that, do you still desire to be
It's not like coat cold. You don't have to wear a coat yet, but like a sweater, definitely.
considered for first offender treatment?
Yes, sir.
All right. And then Ms. Love is under 1613 too. You are advised that if you're not a citizen of the United States, a plea of guilty will have an impact on your immigration status. Do you understand?
It's 36 degrees right now.
Mr. Taylor, do you understand that?
Yes, sir.
Yes, sir.
Yes, sir.
All right. Oh, listen up, B. Listen, do you understand that you have the right to plead not guilty and demand a jury trial, in which case the state would have to prove your guilt of each element of the crime charged against you beyond a reasonable doubt?
Yes, sir.
Yes, sir.
Yes, sir.
If you plead not guilty, the Constitution guarantees you at trial, among other possible rights, the following: the
Not
right to a
yet.
speedy and public trial by jury, the presumption of innocence, the right to confront and question the witnesses against you, the right to subpoena witnesses and evidence in your favor, and a right to present those witnesses and that evidence during the trial. You have the right to the assistance of a lawyer during the trial. You have a right to testify if you wanted to, but you would also have the right against self-incrimination. That is, no one could make you testify. And if you chose to not testify, that fact could not be held against you or used against you in any way. You would testify or not, and you personally would make that decision. Now, do you understand that by pleading not guilty or remaining silent and not entering a plea at all, you would obtain a jury trial with all of these rights?
Yes, sir.
Yes, sir.
You understand that if you plead guilty, as you're doing right now, you give up all of these rights?
Yes, sir.
Yes, sir.
Yes, sir.
Now, notice that each of your cases involves some time on probation, and you would give up your Fourth Amendment right against search and seizure while you're under this sentence. And you have to agree that as a special condition of probation, you shall consent to a search of your person or property any time of the day or night, with or without your consent and with or without a
I would pay any amount of money to hear him read Huckleberry Finn. Yes.
search warrant whenever you are requested to do so by your probation officer or any law enforcement officer. If anything is found in that search, it may then be taken and used against you in any further court proceedings. Now, do you understand that?
Yes, sir.
Yes, sir.
Yes, sir.
And do you agree to that?
Yes, sir.
Yes, sir.
Tell me the facts and circumstances surrounding the charges against Mr. Taylor and the recommendation, please, ma'am.
Yes, Your Honor. On February 27th of 2024, law enforcement was dispatched to 9202 Watson Road in Kemler County, Georgia, about a domestic dispute. When they arrived, they spoke with the victim, Miss Crystal Taylor, who had a bloody and swollen face, and said that the defendant had punched her in the mouth, held her down, and hit her multiple times after she had confronted him about cheating on her. The defendant was still on scene at the time as well, and when he was being arrested and taken out of this house to be put in the back of the car, the defendant yelled at the victim's dad, Mr. Jimmy Berry, quote, "If I ever get out, I'm going to kill your GD expletive." This was also heard by multiple deputies and the victims as well. The state's recommendation on count 1 is 5 years probation subject to 120 to 180 days in the PDC. Count 2, 12 months probation consecutive to count 1, and this is also with credit for time served. As allowed by law from February 27th of this year is when he was locked up for this and hasn't gotten out. Also subject to a $1,000 fine. And special conditions 2, 7, 10, 11, 12, no contact with Jimmy Berry. And 13 is no harassing contact with Crystal Berry. 14, 15, 16, 19, 25, 32, and 34.
All right, Mr. Taylor, you heard that recommendation. That was recommendation
July, that's the month of July.
that you've agreed to, and the one that you expected her to make.
Yes, sir.
Although you are not admitting guilt, have you decided that it is in your best interest to plead guilty because at the trial the evidence presented may be sufficiently strong for you to be convicted?
Yes, sir.
Based upon that, do you now freely and voluntarily enter your plea of guilty to these charges against you?
Yes, sir.
You're here today with your attorney, Mr. McCrae, who along with Ms. Payne and perhaps others in their office have been representing you. Are you satisfied with the services that they have rendered to you in this case?
Yes, sir.
Anything else you'd like to say?
No, sir.
Mr. McCrae, you heard the recommendation. Is that the one to which you and your client have agreed?
Yes, sir.
You satisfied that he understands all of his rights?
Yes, sir.
Anything else you'd like to say?
Nothing at this time, Your Honor.
All right, Mr. Taylor, the court finds that you understand the nature of the charges against you and the consequence of a guilty plea, that this is a factual basis for the guilty plea, and if you decided knowingly, intelligently, and voluntarily to plead guilty, the court will therefore accept your guilty plea, and I will accept the recommendation that has been made. On count 1, it'll be a 5-year sentence. I allow you to serve out on probation subject to 120 to 180 days in the PDC and a $1,000 fine. You get credit for time served against the 5-year sentence. I'll explain more about that later on. Count 2 will be 12 months probation consecutive to count 1. Now, when you get to the credit for time served is not giving you any credit against 120 to 180 days in the PDC. You don't get credit for that. When you get to the PDC, somebody's going to give you a form that says you fill out this form and send it to the judge, and you get credit for that time you served in the county jail against this 120 days in the PDC. That only counts to a prison sentence. It does not account to a PDC sentence. So save your stamp. Don't fill out that form. Don't send it to me, because if you send me that form, I'm just going to turn around and send you my form that says, no, you don't get credit for that against the PDC sentence.
A new rule, guy. You can't say, honey, you ain't whistling Dixie, because that'll make me giggle. And then follow that with horrific news. Because now I'm giggling. Now I'm giggling at horrific news. Hi, drunken.
So we'll just be wasting paper and wasting stamps, sending it back and forth. You got to do the 120 days. If you behave and do what you're supposed to do, that'll be all you'll do. If you misbehave and don't do what you're supposed to do, you might have to serve the 180 days. That's going to be up to you.
Yes, sir.
You've been sentenced to a period of confinement. It's a violation of the law to escape. If you were to escape, you can then be prosecuted for the new offense of escape and receive an additional 1 to 10 years in the penitentiary. If a dangerous weapon were to be used by you or others in that escape, you could get an additional 1 to 20 years in the penitentiary. Do you understand?
Yes, sir.
You have a period of 4 years within which to petition the appropriate court for habeas corpus relief. If you'd like to know more about habeas corpus relief, I'm sure your attorney will be glad to explain that to you. Thank you, Mr. Taylor. Tell me the facts and circumstances surrounding the charges. Get Mr. Rodriguez, please.
Yes, Your Honor. On January 29th of 2023, law enforcement was dispatched to 2516 Webb Circle in Candler County, Georgia, for a domestic dispute. The female victim in this case, Miss Jeremiah, sorry, Rosie, if I butchered that, about a domestic dispute. The victim, I'll say her first name, Gabriella. I can pronounce that one. Was with a bloody nose and swollen cheek. She stated to law enforcement that her boyfriend, the defendant in this case, hit her in the face during an argument. The other victim, Mr. Solano, was injured when he tried to intervene between the defendant and Miss Gabriella, and that is when he was injured. He had to go to the hospital for his injuries, and it was confirmed that he had a fractured orbital bone, a fractured nasal bone, and a scalp laceration. The state's recommendation on count 1 is 20 years probation, subject to 170 to 180 days in the PDC, suspended on substance abuse and mental health evaluation and treatment, as well as anger management classes and the family violence intervention program. Count 2, 20 years probation concurrent to count 1, and count 3, 12 months probation concurrent to count 1 as well as a $500 fine and subject to special conditions 2, 10, 11, 13, 14, 15, 16, 19, 25, 32, and 34.
I don't necessarily want to prolong this, but this, you break somebody's orbital bone. And yeah, give me some little explanation, because this is
Mr. Solano does not want to prosecute. He does not want to cooperate, and the female victim in this case is actually his bondsperson, and I believe she's in court today as well.
His bondsperson is the victim. Oh my gosh.
all right. Now, Mr. Rodriguez, this is a very unusually light sentence for this sort of a charge.
Yes, sir.
You come back, whether you spit on the sidewalk or step on the crack. I don't know if you understand that analogy or not, but it's not going to take much for you to be in the
DJ, you got to translate that for us.
prison system for a long, 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 long time under these charges.
Yes, sir, I understand.
Because, you know, I don't know what all went on, don't know what all was involved, but it doesn't matter. You got to learn to walk away from whatever it is.
Yes, sir.
You can't afford to stand and fight. You got to walk away. You got to swallow hard. You got to swallow your pride. You got to walk away and say, I'm not getting involved in this fight or this dispute, because you come back and it's not going to be pretty. I want to make sure you understand that.
I understand, sir.
So much wisdom today, guys. We can't handle much more.
I don't want you to take this leniency as thinking that this is all right. It's not.
It's not, yes, sir. Understand.
All right. You heard that recommendation. Is that the recommendation that you've agreed to, and the one that you expected her to make?
Yes, sir.
Based upon that, do you now freely and voluntarily admit your guilt of the charges against you, admit the facts as stated by the prosecuting attorney, including her description of your conduct that forms the basis of these charges, and do you enter your plea of guilty to these charges against you?
Yes, sir.
You're here today with your attorney, Ms. Payne, who along with Mr. McRae possibly have been representing you. Are you satisfied with the service that they rendered to you in this case?
Yes, sir.
Is there anything else you'd like to say?
No, sir.
Ms. Payne, is anything, you heard the recommendation, is that the one to which you and your client have agreed? Are you satisfied that he understands all of his rights? Is there anything else you'd like to say?
No, sir.
All right, Mr. Rodriguez, the court found that you understand the nature of the charges against you and the consequence of your guilty plea, that there is a factual basis for the guilty plea, and that you have decided knowingly, intelligently, and voluntarily to plead guilty. The court will therefore...
This attorney is practicing behind the bar. Is that legal?
Or accept your guilty plea, and I will accept the recommendation that has been made. Because count one, it'll be a 20-year sentence. Allow you to serve out on probation, subject to 170 to 180 days in the PDC. So I'll suspend that upon you completing mental health evaluation and substance abuse evaluation, and take whatever treatment they recommend. Also, you are required to do anger management classes and family violence intervention program, and there will be a $500 fine. Count two will be 20 years probation concurrent to count one. But you come back and I can make that 20 years consecutive to count one. So you're looking at 40 years, whatever is left of a 40-year sentence. If you come back here test positive for drugs, get into another fight, any kind of thing like that, it violates the terms and conditions of your probation, is not going to be pretty. You understand that?
Yes, sir.
All right, count 3 will be 12 months probation concurrent to count 1. That will be the judgment and the sentence of the court unless you'd like to withdraw your plea. Would you like to withdraw your plea?
Yes, sir.
All right.
Even the way he says pretty is nice.
Tell me the facts and circumstances surrounding the charges against Ms. Lovett, please, and the recommendation.
On December 29th of 2022, there was a traffic stop in the area of South Leroy Street and East Versia Street in Candler County, Georgia for a headlight violation. The trooper who made the stop believed the passenger, Mr.
Judge King, is that, that's Washington, right, Raven?
Loach, was trying to hide something in his mouth. It being a small package that was swallowed, EMS was called and he was cleared at the scene. The trooper then ordered the driver, Ms. Lovett, out, and consent was given to search her purse, in which there was a straw with suspected cocaine residue inside. The driver then gave consent to search the entire vehicle, where a plastic bag with suspected cocaine was found. And that did come back positive as cocaine in an amount of less than 1 gram, and neither of the co-defendants claimed it. So both were charged.
And the recommendation? Oh, and go ahead and get me a comeback. Somebody on Ms. Lovett, I want her back in 90 days. I want to follow her up on her. Make sure she's not using.
The state's recommendation is 3 years probation subject to RSAT, with RSAT being suspended upon the successful completion of the ASAM 1 program, as well as a $500 fine and subject to special conditions 2, 8, 10, 11, 15, 16, 25, 32, and 34.
All right, Ms. Lovett, you heard that recommendation.
Oh, that sucks. I hope he gets better.
That the recommendation that you expected her to make and the one to which you have agreed?
Yes.
Based upon that, do you now freely and voluntarily admit your guilt to the charges against you, admit the facts as outlined
Yes.
by her, and enter your plea of guilty to these certain charges against you?
Yes.
You're here today with your attorney, Ms. Payne, who along with Mr. McCray perhaps have been representing you. Are you satisfied with the services they have rendered to you in this case?
Yes.
Anything else you'd like to say?
Not at this time.
Ms. Payne, you heard the recommendation. Is that the one to which you and your client have agreed? Yes, satisfied that she understands all of her rights? I am. Anything else you'd like to say? All right, Ms. Lovett, the court found that you understand the nature of the charges against you and the consequence of your guilty plea, that there is a sufficiently strong factual basis for the guilty plea, and that you have decided knowingly, intelligently, and voluntarily to plead guilty. The court will therefore accept your guilty plea, and I will accept the recommendation that has been made. A 3-year sentence. I lay to serve it on probation, subject to RSAT, but I'll suspend RSAT upon you successfully completing the ASAM 1 program. And there'll be a $500 fine. Now they're going to bring you back before me in 90 days. And if you've tested positive or you're testing positive, then we're going to be looking at RSAT for 9 months, bottom line.
I understand.
So when you get ready to do how you do cocaine or whatever else you do, you think about it and say, do I really want to go to RSAT for 9 months? Nah, is this worth it or not? Maybe not. So think about that, okay?
Yes, sir.
All right. Thank you all very much. Yeah, I don't want to confuse Ms. Wilson with numbers, so let's go with whatever she got on there. Yeah, that'd be fine. Well, that's getting worse, isn't it? She can't even remember what month she's in. Oh, goodness. But we did go through
All right, if that wasn't the greatest thing you heard today, I don't know what to tell you guys. That was awesome. His laugh was awesome. Okay, this is where I fell asleep somewhere around here. This is where I should have stopped it, but then I woke up 17 minutes later and said, oops. And then I named this clip Needs Cut because I was supposed to cut this down, so we weren't gonna have this whole conversation that we're having right now, but then I just didn't. And look, it turned out fine. All right, it's time. This is exactly where we stopped yesterday. Don't do that. All right. So, right, this is exactly where we stopped, right? I barely remember yesterday, actually. I was really, really, really tired.
He's got to sign. Ricardo. Oh, you'll get paperwork here. Make sure to write down everybody's phone number here, and then, we can give you paperwork here as well.
Families here, Judge. I'm gonna get the numbers.
Yeah, you'll be able to work things out, but just don't forget, don't be Helen Keller, because it's just not going to go well. Okay, man. Good luck.
And we start with the Helen Keller.
You too.
Judge.
He's got to sign. Ricardo. Oh. So you kneel back out? No. You're waiving formal extradition, right?
Yes.
Yeah, okay. All right, no, we're good.
All right.
Thank you.
We'll bring you back there for the sign.
Hey, Ricardo.
Judge, we're approaching on Mr. Ramon Barahona.
Do you need until Monday?
No, because here's what's going on. So I was kind of unsure about what he was talking about, and after
Before I move on to the next one, I got to tell you guys a quick story. So after work tonight, no, sorry, that doesn't make sense to anybody except me. After work last night, which was just a couple hours ago, Bill was on. So I got into his stream while I was at work, into his chat, right? Well, then I had to drive home, but I didn't want to leave his chat. So I gave my phone to my daughter, and I'm like, look, you have to chat. You have to be me in this, okay? So I'm listening to the stream in case somebody says something, and she has my phone in her hand. And she got irate at everybody. She was up to here with everybody. She's like, what in the heck is this? Everybody is only just saying hi to everybody. Why don't you guys just come in and say hi, guys? That's it. You don't have to say hi to everybody. Well, it didn't. It never stopped. The whole time we're driving, she's getting madder and madder. And then Nan came in the chat. And I saw it because, like, my name, shows up. I'm like, what was that? What was that? She goes, Nan said hi to you. I said, you have to say hi back. She says, no, I already said hi, guys. I said, you have to say hi to Nan. You have to say hi to Nan right now. So she typed it. And I think I can't remember. I don't remember. I think I said you have to put like 3 kisses behind it or something. I don't know if she did. But she was like, no, I'm not doing it again. I'm not saying hi to every single person in this chat. I'm not doing it. So then Linus came in. Now I had already said hi. I personally had said hi to Linus at the bar. Well, Linus came in and said hi to me. And my daughter knew I already said hi to her. So when Lena said hi to me, she says, absolutely not. There's no way. You already said hi to her. We are not saying hi again. And I went berserk in the car, and I'm like screaming, no, you have to say hi to Lena. You have to give her kisses. Stop it. You have to say hi. And she's screaming back, no. I'm not saying hi to, well, she said Linus, but how was she to know? I'm not saying hi to Linus. I'm not. You already said hi to him. No, that's Linus from the Netherlands. You got to say hi. And this is our car ride home. And we're screaming at each other. And she did. She did. I said, look, you can say hi again, Linus. And that made her feel better. So she typed hi again, Linus. And I think she put 3 kisses after, I think. But she was like, how can you guys do this every day? This is horrible. You just say hi, guys. That's it. Never, ever expect my daughter to say hi to anybody personally. It's never going to happen.
Talking to him, we're not going to have a breath result for him because they haven't been testing him, is what it sounds like. And so we got two options, Judge. The way I see it is two options. One, you could revoke them. You could say, well, let me talk about what the specific is on the revocation. Alcohol was detected during tamper. However, alcohol cannot be confirmed as consumption because of nature of tamper. So I would argue, I'm not conceding that something happened. I'm conceding there.
I hate to say this, but if I make her a mod and everybody starts saying hi to each other, we're all gonna be banned. She's gonna ban me. I don't feel safe at night sometimes. I'm not gonna make her mad. She's the middle child.
Might be a tamper. I'm not.
Come up, Mr. Barahona.
If you're gonna revoke him, I would ask for a full-blown hearing. If this is one of those situations where he's just admonished and, hey, this is your one shot, then he understands that. I don't know how you want to proceed with this, Judge. I'm not conceding that he drank alcohol. He's been in this location, in this Center Core location since September 17th. He did.
You guys probably know this already. I don't know. Something is going on with this guy's hair. I don't know what it is. All as I know is something, we have to watch the hair for some reason.
Patient, October 18th, he graduated. Then he moved over to Center Core's sober living facility on October 18th. He's been in there since then. We have proof of that. He's been attending 6 meetings per week, 1 counseling session per week, 1 group counseling session per week, 3 AA meetings. He's there. He's doing something. I would ask that we just admonish him.
Machines don't test positive for shites and giggles, man. They don't. There has to be something there to make it test positive.
Well, Judge, on that aspect,
it doesn't spontaneously test positive for alcohol.
Well,
for you to say that it does, it's just disingenuous and not true.
Does anybody know the 100% correct spelling of shice? Don't guess, because I'm thinking about making it one of my shirts that you can buy, shites and giggles, and I can't have it spelled wrong. I don't know if that's right. I think it's different than that. So I don't know. Or I'm wrong and that's correct. That's how to spell it? Kelly? Where's Kelly? No, and there's Donald. I knew it. I knew you guys would all give me completely different spellings.
There has to be something to set the machine off. It doesn't spontaneously test positive.
That won't, no one will understand. That won't, I can't. All right, we're just going to watch the judge because apparently we're supposed to watch this.
I have not consumed alcohol for 51 days as of today.
The machine is telling me differently, Mr. Barahona. You know how many people?
Yeah, you know what, guys? It's 5:54 in the morning here. 4:54 with the judges. I'll just call him quick and see how to spell it. Hi, Crystal.
Will tell me the same thing with the exact same facts that you have. You know how many times I hear it a day?
I would assume a lot.
If I had one strand of hair every time I heard it, I would look good.
Judge, I did talk to him. This wouldn't be much of a solution since this is from 1026, but we could test him today. I don't know how long something stays in the system, if that's the allegation, but he's willing to test today.
That's going to be no bearing on me.
Right.
I mean, this is 2 weeks ago, you know? I'm just now, unfortunately, they just give us the results now.
I haven't used alcohol for at least 51 minutes.
And regarding the actual, I've gotten reports before that says what this device is reading. There are reports out there that they can provide.
If they don't tamper, then yes, you will get a true and accurate reading. And that's what the problem is that there is something that was tampered with, and Mr. Barahona knows. He's the only one that knows what happened on that date. We don't, because we weren't there. We don't know what happened. So I'm sorry, Mr. Barahona, but I told you one thing, and I told you one thing only, you know?
I would like to state the fact one more time that I did tell the people at Sentinel to tighten it because I didn't want something like this to happen. I don't
This
think
is
it's
not a matter of tightening. It's a matter of alcohol detection. If a device is loose, it's not going to test positive for alcohol.
Me too. We just have
You
to
understand
delete
that?
it.
I
Just,
understand what you're
there has to be an intervening event that has alcohol in it for it to test positive. And there's something seriously afoot because the device is telling us that someone is messing with the machine. If we not had the messing with the machine, then we would know whether there was true alcohol consumption or not. But here we have a positive and that you're messing with the machine. Okay, goes with you.
All right, look at the hair. Something happens. Nothing happened with the hair. I don't understand. I don't even know what's going on with the hair. I looked.
Come on up, Ralph.
And lights.
Hey, hey.
Lights, I am happy that any other channel plays Judge Fleischer. He's amazing. He's so damn good at his job.
Set it high, I'll set it at 2501, and then
we have an actual hearing,
Yes,
Judge?
I
Sure.
mean,
Bring
shit,
witnesses?
shits and
Sure,
giggles.
of course.
Shiesty.
Next week, whatever day. I mean, we got to give them at least a couple days to get subpoenas out, though.
I don't think it would make a good shirt because I don't think anybody would get it.
Okay. Okay.
Yeah.
I'll talk to the prosecutor, see how many days they're looking for, and we'll try to set something up.
Sure.
All right, thanks, Judge.
Yes, sir. I got Miss Nambo. She came back already. I don't know. Maria Nambo.
No. Barahona.
Is that for the ambulance? Like, I guess fire truck, ambulance. Pity. Come here, pity. That's, I mean, how? How is someone supposed to pay that? There's no way I could pay that. None. So you get $100 a day in jail. All right, I could pay it off in jail time. Yes, sir.
Okay, who do you got?
Miss Nambo, you sent her to a drug test.
Okay,
She's back.
come up, Ms. Nambo.
Judge, she tested positive for alcohol and cocaine.
Do you see how many people we've put into custody today?
Yes, sir.
It's like every other person.
Oh, no, I wasn't here.
You put a lot of people in custody because they continue
Right,
to
Scheisen.
violate.
But I don't think anybody would understand the shirt. Yeah, even if I put that.
Conditions of bond. No more using cocaine. No more using alcohol. You just were up here not too long ago preaching about this and preaching about that and that. You testing positive for cocaine now tells me it's been used within the last 2 days. So I will now test you 2 times a week to make sure that you're not using. And the next time you test positive, you're going to stay with me. And if it continues to happen, I will have a hearing as to whether we'll hold you in contempt. And if they continues to happen, I'm going to put you in a rehab facility. It's going to stop. I'm giving you the opportunity now to do it on your own. If you're unable to, we will do it my way. And I promise you, you're not going to like the way that I do it. Do you understand? We'll see you back on Monday for another test.
I'll come here.
Yes. Yep. Vic,
Oh,
another Monday, Thursday. Okay, Judge. Hey,
How are you?
Friday, man.
Happy Friday for real. Jesus Macias, Your Honor, this was the one that was up here a little earlier.
Is it, you said?
Macias, he's the one that picked up, I just got to point it on the day.
Oh, yeah.
Yeah,
Okay.
the
two new assaults.
2 new assaults.
Yes.
Okay. All right. So I talked to Mr. Macias for a while, and he was going to share with you a few things that would kind of help give some more context in the case. On his 2 known law violations, there was a rip call that was made to his the complainant, and the complainant basically said kind of what verbatim what Mr. Macias told me, that he was actually attacked by her family. He called 911. When he called 911,
Not you don't get a shirt. If you haven't hit the like, you don't give a shirt.
she became very upset, made up the story of the assault, never saw the brother be assaulted. So you have, on the 2 new assaults, you have brother on one, and then you have wife on the other. So she basically
This is the Michigan judge. That's where he lives, Michigan.
recants and says that the assault on her never happened, and she says that she doesn't witness anything as far as with the brother. Okay, those are the 2 new law violations. She also makes a reference to the first assault, which he's currently in the court as well, and said that was made up as well. Now we have people that recant all the time, but it would be.
I mean, I'm not going to take his word for it just because it's right.
Well, no, of course, Judge, but it should be noted as far as on this recantment as well, that she actually asked the state that she need representation for the false report. So that's a little bit different. That's usually, you don't usually have it to where people are concerned about getting representation for making a false report. That's usually a little bit extreme, so to speak. She's actually asking for it to be dismissed.
He's on bond for an assault against this person, picks up another assault.
He can't tuck his shirt in because he's handcuffed. Maybe Steven should help him with that.
Right, and then another assault against another person. I'm putting an order for protection in, and I don't want you to have contact with this person. I'm still going to take you in. I mean, I have something that's said here. People recant all the time after the fact because for whatever reason, but I have something here. I think that there's enough evidence to go forward. And I think that I believe that probable cause did occur. I'm not going to take your word as gospel. I don't know. Maybe the facts will show something different later on, but the evidence is going to point to whose side is correct. I don't know. Perhaps there'll be photographs. Perhaps there'll be body cam footage of what a person looked like. I don't know. But this is stuff that we got to wait for to see what happens. But
Your Honor, we're also approaching on bail, being that we do have a recantment, and the recantment was pretty quick. And the complainant is also asking for a dismissal. We're going to ask for a PR bond on. This is the thing. I would definitely argue that there's going to be. I mean, at the very least, then, if that's the case, then I would like a speedy trial, because if we're going to.
Yes, and I'd be happy to give that to you.
I would rather do that.
And I absolutely love your tenacity.
Oh, I want it. I
love your tenacity, but on the PR bond.
Understandable. Well, we know that you wanted to set a bond, Judge, so
I did. I set it at 15,002 because I want you to understand.
Because there's gold fringe on the flag.
That we mean business, and my utmost important is public safety, and that's the only thing that matters to me. Do you understand? And if I find that you have contact with this person, and I don't care what is going on, so help me. Do you understand?
I understand, Your Honor. Judge, that was 15,002 on the old case.
Yeah.
And on the new cases, those are going to stay at
Leave it as
1,000.
is. I'm going to leave it as is. I'm not going to touch it what the magistrate did, but I'm just going to revoke the old one because he picked up the 2 new cases. I'll leave as is. Within my right to revoke it and raise it and make it higher, because I think that you're an utter danger to public, right? I'm not going to, but understand that we can't. And if I find that you violate any of these conditions, I will go nuts on the bond. Do you understand?
Understood, Your Honor.
Okay. We've given you a lawyer. It's your responsibility to stay in touch with him. When you get out, you will have an ankle monitor, so I know where you are at all times. You're not to go within 200 feet of where she lives, or he lives, or where they.
I am positive. I am positive. I heard someone tell me the gold fringe means it's Michigan. I'm positive.
work. You understand? We will see where it pings at all times. So if you go anywhere near these people, get ready. I will give you the speedy trial. I need to give them at least enough time to get their evidence, to get their motions and subpoenas in line, which is at least 30 days.
And
After that,
I don't press the state. I've worked for the state before, so I
so
can be amenable to a time that works for them. I just want to be fair to him as well. on custody.
I mean, it would be probably in January, but whatever date then, we're gold, whatever you want. Yeah, of course. All right, thanks. Wait, hold on a second, because I don't think. Okay.
And I know.
Can you also, well, no, we got conditions with, okay.
Right, and as soon as she's ready and we can, I'll bring them back out. I'm not sitting them down.
No way. Drunken, are you sure? Are you sure gold fringe just means it's decorated with gold fringe? Are you sure? Because I'm pretty sure someone told me that means it's Michigan.
Money.
Well, you won't be able to sign with just.
Ms. Shealy.
Hi, good afternoon, Your Honor.
Hey.
I'm here on Mr. Kareem Khalifa, and he.
I had a beef chalupa. I did. I had a beef chalupa. Yeah.
I don't believe has ever checked in. So.
Okay, let me see. Yeah, he has a felony warrant.
I know, Your Honor, and I told him he had to be here today.
Oh, you actually spoke to him? Oh, what happened? I thought that we were gonna do so well with him. Did he just not show up upstairs? Is that what
All of
happened?
his cases are against the same complainant.
I know.
There's a lot of flags with gold fringe on it where I was. So yes, I was in Michigan for text backs.
To violate his bond, he's still contacting her.
Really?
He's
Your Honor, I mean, I know he told me that his mother lives there and his mother had an emergency. So, but he didn't show up today. So we'll just deal with it when.
You're telling me that he's still contacting her too?
Yes, Judge. She is very afraid of him.
I guess 10,001, and then,
Does he have two? He has two cases.
Oh, yeah. Okay, so both of them at 10,001.
Okay.
Jethro, are you in Tulsa? I got a link for you. Hold on. I got a link for you. It's right here. There. Oh, never mind. It's Tucson. I got it. Wrong. I'm not muted. I'm not muted.
I didn't realize he had both of them. Yeah. Yep.
Okay. Thank you, Your Honor.
Okay, thanks, Ms. Sheilick. And then, will you stay on it?
I'll stay on it. He is very.
Yeah. And then we'll just give you a heads up because at some point we'll get him.
Y'all can let me know.
Yeah, absolutely. Whoa. Who's this?
Oh, nice.
Yeah, you make more than I did. Shoot. What's the name?
That is. Just Perez, Leyva.
Ay, ay, ay. Really? Okay, come up, Will. I should.
Maybe her date did it.
Huh? What?
Maybe her spouse makes that one.
Okay, just so you guys know something right now. There's Will, right? And right here is both Allie and Linus. There's Will. And Victoria. Hi, Victoria. I love you. Happy birthday. Yep. I wasn't there and it's not there.
Okay, I'm sorry.
Mr. Barrett, James
Back there and.
I mean, one wrong move and he knocks them all off the chair.
Okay.
I believe it was discussed earlier about the MOAP because my client.
Oh, that's right. Okay.
They all live together. I spoke with my client who's here and his wife, who's the sister of the complainant, and they all three do live together. My client's wife is the caretaker for both my client and the complainant, and they've ripped and we're all good.
And the MOAP to take off the residential restriction, no contacts, and then just let them know, just no threatening, harassing.
Okay, so no contact.
No contact, right, yeah. Thanks. Okay, we'll take care of that now. Just make sure that he gets a copy, huh? Yeah.
Judge, state's ready on John Melendez.
Okay, we'll do that now.
Yes, Judge.
Come up, Mr. Melendez.
He did. He really did. Yes, he did. Yep, he did. It was really cool. And then we had like a great dinner with great conversation at dinner. And then Linus was there, so some of the conversation was, about the cultural differences, and then the rest of the conversation. Well, first off, Allie is a master at holding up a conversation. So, while we're just taking everything in, she's keeping the conversation flowing. But no, the judge had, he was talking about all kinds of stuff, and it was just great.
Are you with him? Who are you? Come on up, Mom. Thank you for coming. Thank you for coming. Mr. Melendez is charged with unlawful carrying of a weapon. He's facing up to a year in jail and or a $4,000 fine. The last that we were doing probable cause, and I wanted to see whether there was actual probable cause to go forward or not. From what I gather, I mean, do you want to go ahead and read it so that she can hear it? Do you mind?
Yes, Judge, I can.
Okay.
So these charges stem from an evading arrest in a motor vehicle. This defendant was the back passenger in the car. Officers attempted to initiate a traffic stop at around midnight after observing the defendant vehicle run a stop sign. Officers activated emergency lights and sirens, and the driver of the vehicle disregarded them, turning off all lights in the vehicle, attempting to evade arrest. The driver drove for approximately 0.4 miles before driving off of the road and into a grassy area. A felony traffic stop was conducted. During the search of the vehicle, officers discovered an unholstered handgun on the back passenger floorboard where the defendant's feet were. They also found another handgun underneath the passenger seat itself.
So they found two handguns?
Yes, Judge.
But this was an initial.
I know.
So
it's not in the.
Where's the first gun?
The first one is directly under the defendant's feet. The second one is in front of the defendant under the passenger seat.
Okay.
So one on the floorboard directly in front of him. He has care, custody, and control.
I didn't see anything wrong with the last guy's hair, and I don't see anything wrong with his hair either.
And one of them directly under the passenger seat in front of him, which is unoccupied. And the defendant was also found, the gun was reported stolen notably, and this defendant had latex gloves on his hand at the time.
Do you have anything else?
No, Judge, the co-defendant was charged with evading arrest in the motor vehicle and unlawful carry of a weapon, pinning the gun under the passenger seat on him. So the gun under the floor, on the floorboard where the defendant's feet were, we are alleging is this defendant's gun. He has care, custody, and control of that. The one under this passenger seat is the defendant driver.
Yes, with the fact that he has a glove on.
Yes, Judge.
Mr. Stop. Now's not the time. You have the right to remain silent. Exercise that right. How many people did you say were in the car?
Two people, Judge. Defendant driver and defendant passenger.
Who is the driver?
The driver.
In what relation is it to Mr. Melendez here?
They both are 17-year-olds, Judge. It looks like they may be friends. I don't know if there's any other relationship, but they're both 17.
What do you do with yourself these days? Doing what?
Auto detail. Auto detail.
Did you graduate from high school?
Not yet.
Are you in high school?
In a program.
What's he doing with himself these days, Mom?
He's working full time.
That
But he's
might
not in
be
school.
tape.
He was currently doing a
Tape on the
homeschool
floor.
program, but I got behind on the payments. So until I can catch up, he can continue his homeschool program.
We have resources here that can help you get into free schooling to help him because I want him to get his GED. He cannot go around without a minimum of high school education because you will amount to nothing in this life. This life is about one thing, and this country is about one thing. And if this last election shows you anything, this country is about one thing and one thing only. This, the almighty dollar. And if you don't have money, you don't have anything. You will not have anything in life. You will not have a wife. You will not have a house. You will not have vacations, car. If you don't have an education, you will not have money in your life. The journey that this life is, it's either a great journey with money, vacations, things to do, or it can be a rotten toilet of an existence where you're in and out of jail, no money, living on the street, begging just to be able to eat. You are now at 17 with no prospects. It's not going to happen anymore. This system will not fail you. Do you understand?
Sir,
If I go test you now, what are you going to test positive for?
it's marijuana.
I'm sending you now. What else? If you're lying to me, it's not going to go well for
Shouldn't
you.
be.
I'm sending you now because I want to know what, if anything. You are not to hang out with this person anymore in the car. Do you understand?
Sir.
You are to get back into school or start any kind of program to start working your GED. And I will test you. And the next time you test positive for anything, I'm going to keep you with me. Chances are your mom doesn't have a lot of money. I'll make it a high bond. Your butt's going to stay in custody. You get my drift.
Sir.
I want him to follow your rules. And if he gives you any grief, any kind of headache, you let me know and I'll take care of it. I really want what's best for him. And if he's out in the middle of the night, hanging out with, it's not going to happen. So I'm also going to put a curfew on you so you're not out in the middle of the night.
Does everybody from Michigan talk like that?
Do you understand?
Sir.
No weapons as well. No drugs, alcohol, random testing. We will test you to say we will test you today to see what you're going to test positive for. And we'll give you a weapon. I'll give you a weapon. I will give you a lawyer. No weapon. I will give you a lawyer and I will pay for everything for you so that nothing comes out of your pocket. But understand, I mean business and I will not take any excuses from you. Do you understand, Ms. Molina? Okay, man, take a seat. 10 p.m.
Oh, it's the decorations. I think it's part of the decorations that are like this one over here. Because they had a whole bunch of fall leaves decorated.
Yeah.
Do you need us to file that?
No, we're gonna monitor him like crazy.
Ahora aquí en el centro, por favor. Buenos días. Tardes ya. Éramos Luis y Lita. Acérquese, por favor. Gracias. Y le contesta en español al juez nada más. Solo mirlo, solamente miro el juez. Gracias.
When you apply for a court-appointed lawyer, you have to qualify. If you make too much money, you just don't qualify. In the affidavit you filled out, you're stating that you make $8,000 a month.
Yes, sir.
This is true.
Si eso es verdad,
Don't qualify
no
for an
califica
appointed
para un
lawyer,
abogado
man.
de oficio. Quedar más tiempo. O solo mire el juez, por favor.
You really make $8,000
¿Ya
a
gana
month?
$8,000 por mes?
Es que eso es algo que no,
Solo mire el juez. Y
que
hable
no
con él.
sabría decirle porque
I want you to tell me the truth.
It's just something I wouldn't know what to tell you. Me gustaría que me diga la verdad.
I know how much money
Usted sabe
all
cuánto dinero
sources.
gana.
I just need you to tell me the truth. Do you really make $8,000 a
¿Ya
month?
gana como $8,000 por mes?
es que no sabría decirle porque no sé exactamente lo que hago por día. Varía, en el día puedo ser exactamente $100, depende.
Well, le pido por favor que no me mire a mí, solo mire al juez. I couldn't tell you with any certainty because it varies, my income from day to day. I could make on one day $100, but it depends.
I don't want you to engage in this
Yo no quiero
behavior
que se involucre en
anymore.
este comportamiento ya más.
I want you to understand
Yo
that
quiero
if you
que usted
continue
entienda
with this,
que
I
usted
will put you in
continúa
jail.
con esto, no
You are
poner en la
not
cárcel.
allowed to continue
Y
with
no
this type of
va a poder continuar con ese tipo de
income, so to speak. Do you understand?
Sí, ¿usted entiende?
Ujú.
Tiene que hablar.
Knowing
Señor,
that.
señor, tiene que hablar.
Sí, señor.
Yes, sir.
Knowing that,
Sabiendo eso,
what kind of income do you have coming in? Are you married?
¿qué ingresos tienes? ¿Eres casada?
Sí,
Yes.
What does your husband do?
¿A qué se dedica su esposo?
estamos casados, pero no mantengo una relación con él.
I'm married, but I don't maintain a relationship with him.
Get any income from
¿Usted
him?
recibe ingreso de parte de él?
No.
No.
Do you have children?
¿Usted tiene hijos?
Sí, pero en Cuba.
Yes, but in Cuba.
She does what Fozzie does for a living.
Guess what we can do is I can send you home with an application and you take time, think about it. But I need to know what your true income is.
En realidad, ¿cuál es su
And
verdadero
then if you qualify, we'll give you a lawyer, but I really need to know what your income is. And
Necesito saber.
8,000, just you don't
8,000.
qualify. So I'll send you with one. But I want you to understand, you're not to engage in this behavior.
Se puede involucrar en ese
So when you fill out this application, it's not taking this into account.
consideración.
Do you understand?
¿Se entendió?
Sí, señor.
No more of this.
Ya no más de esto.
Sí, señor.
Yes, sir.
Okay,
Okay.
all right. Please.
Pase a la izquierda, por favor. Agarre su bolsa. Uy, qué lindo.
No, I'm gonna send her just like maybe 2 weeks to give her to fill it out, give her time, and then we'll take it.
Judge, was Mancias approved for a walkthrough?
No,
Do you know what the amount of the bond will be
15,002.
on both?
No, just the old assault, it's 15,002.
Okay, they can't do anything. Okay.
No, I'm not leaving. Fix up just 3 assaults, once you go walk through. What did you ask me?
Montaner. No driving affidavit or bond conditions?
No driving affidavit, yeah.
Can you
Hmm?
do the paper?
I thought I,
No, you didn't.
okay.
Yes, we love to see it happen.
Okay. Okay, Ricardo. Yeah.
As we're approaching on Ramon Barahona.
Yes.
I wanted to see what kind of bond you consider for him. He was originally at a GLB bond, so he didn't pony up anything. He'd be ponying up money to get out this time. I think you mentioned that you consider a low bond. I'd like to figure out how low you go.
I normally, when something like this happens, I set it at 5,001.
5,001?
But I'm gonna do 2,501.
The only thing I would say is, I would ask for a $2,000 bond because the person that's gonna pony it up is his mother. And I asked the mother, hey, what can you do? What do you work? She cleans houses.
Okay, I will give it to you.
2,000? Okay.
But just caution them that if he violates again, they'll probably be on the hook for the entire amount, so that they, are fully aware.
Yeah. Let me talk to her. I'll tell her what it is. You'll do 2,000? You'll do 2,000, you said? Okay, sorry.
2001.
2001. Okay, let me let her know.
Sure.
And we'll go from there. And I'll just reset it out after I talk to her. All right, thank you, Judge.
Ricardo, let me look at something else.
Yes, sir.
Okay. Felicia,
Yes, sir.
what'd she test positive for? Anything else?
No, just here.
No more. You will be tested 40 days from today. If you test positive again, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Sure.
Josh, what's your last name again? That's right. 40 days from today, maybe 42, maybe 45, I will test you again for marijuana. If you test positive again, or if you consume alcohol, your bond will be revoked. You will go into custody. I'm also entering in what's called a magistrate's order for emergency protection. And what this is this is a court order that identifies Caleb Precious Booker as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of 225 South 13th, apartment 18. Do you understand? You cannot go within 200 feet of where she lives or where she works. If you violate this court order, the state will file additional charges against you, and then things will go sideways really quick. Do you understand?
Sure.
No contact whatsoever by any means.
Sure.
Okay, so what we'll do is we will reset the case for about 42 days, 43 days, 45 perhaps. And then she must be here at the next setting. And then just if you don't mind letting them know, we've issued the order for protection. So if somehow Ms. Booker reaches out to the person, then warrant issues. We've given you a lawyer. It is your responsibility to stay in touch with Josh, and he will tell you when you have to come back to court. If Josh tells me that he can't get a hold of you, I will issue a warrant for your arrest.
Sure.
Do you see how many people we've put into jail today?
Sure.
Do you know why?
Yes, I was listening.
Good. All we want are streets to be safe. And as long as you can do that, then you and I will be best friends. Otherwise, you got it. Okay? Good luck, Ms. Booker.
I've never acted ladylike.
Thanks, Josh.
Female. Live. Monica, go like this. Then you'll know. Not like this, they can't.
Sunday. Yes, sir. Approaching on Mr. Thiller. Just got the appointment about 10 minutes ago, Judge.
What's the last name?
Thiller, C-U as in cat under Eric.
Do you hear that?
D'Anthony Sweller.
Spanish speaker.
Oh, he's a Spanish speaker, John.
Oh, I guess they have to reassign that. And with that, I guess you guys have a good weekend.
Okay.
Not much I can do after that.
Well, hold on, John. Hold on. What?
Sure.
Okay. Okay, just go. I'll get in contact with you if there's an issue. Okay.
Yeah, I mean, if I'm going to stay on the case, usually they appoint that to a Spanish.
I got this. Tomboys are girls who don't act ladylike.
Speaking attorney, I don't mind.
Yeah, no, John. I mean, we can't. That's not going to work. Okay. What's the last name?
Mr. Davis.
You want me to go, Judge?
Yeah.
Okay.
We'll
Take care.
reassign
Have
it.
a great weekend, Judge.
Okay. Yeah, got it. 24 and 20.
Pay attention to the judge, not the computer.
I see my face on, bro. Yes,
Good morning, Mr. Davis.
How you doing, sir?
Mr. Davis, you're charged with 2 cases. You're charged with driving on a suspended license. You're also charged with fleeing a police officer. Both of those cases are Class B misdemeanors. You're facing up to 6 months in jail and or a $2,000 fine. What if they worked out?
3 days with 6
On both or on one?
Just on one, they're clean on driving while license.
Okay. The agreement is 3 days in jail, credit for the 6 days that you've done on the suspended license case. And as part of the plea bargain, the fleeing a police officer will be dismissed. Is this how you guys understand the agreement?
Yes, Your Honor.
You're giving up a lot of rights by entering into the agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal.
Drunk, I disagree with what I said too, but that's besides the point.
Once you plead guilty, you can never change this or undo this. It will go on your record. And it's very possible that DPS suspends your license because of this case. So before you start driving, I would reach out to DPS because if not, they'll pull you over. And how do you plead to the offense? Are guilty or not guilty?
Yeah, apparently AI court vibes was not a hit. Did not go over well. Nope, there was a lot of complaining going on.
I will find you guilty. I will follow the agreement. He still has the case upstairs as well, or does that take care of this?
It's still open, Judge.
Okay. So it takes care of the cases now here. Unfortunately, you still have the case upstairs. Once you make bond on that, then, okay. All All right, sir. Good luck to you.
Sir.
Thank you.
Have a nice day.
Yes, sir. Thanks.
Look, he's still complaining. It's hard to giggle when it's just you and a camera. There is no such thing as a tomboy. Girls are girls.
Hey, Victoria. You appointed, John got a Spanish speaker. No, he said he got Del Cid Morales.
Alderman?
Yeah.
17.
Okay. You've heard every other 17-year-old what I've said to them here.
Sir.
It applies to you as well. This system will not fail you, and we want to make you leave better than you came here. So you will be expected to fulfill conditions that we put on, and if you don't, we have one place for you. Do you understand? The dope stops today. I will test you 40 days from today. Police, he just tested positive for marijuana or anything else? Where?
Alcohol as well.
Now I'm putting a monitor on you so I know that you're not consuming alcohol.
I don't drink. I just took a shot for my friend's birthday.
Okay. No alcohol.
I don't even like drinking.
Okay.
I don't drink. I just drank. I don't drink, but I just drank. No, she doesn't need to speak to him. Well, no.
No alcohol. Do you understand? If I find that you're consuming alcohol, if I find that you're consuming illegal drugs, you smoke marijuana, I will put you in jail. I will test you 40 days from today. And I'm not going to take excuses that I was in a car, everybody else was smoking, I went to a party, I don't care. If you put yourself into that situation, only one thing's going to happen. Stay away from it, not while this case is over with, until this case is over with. I'm going to bring you back in 2 weeks, and I want to see what you've done to either get back into high school or start working on your GED. That means enrollment. And I will give you a list of places here before you leave, so you know where to go to start looking into, to start calling around to get your GED. If you fail to do that, it's not going to go well here. Do you understand?
Sir.
And that's why we love you, Raven.
Look on the TV. That's John. He's been appointed to represent you. That is your lawyer.
He's better
It
than
is
me.
your responsibility to
Very much so.
stay in touch with him. If he tells me he can't get a hold of you, if you pick up a new case, you start acting a fool in the free world, I will take the free world away from you in a second. All I want you to do is not act like a child. You act like a child, I'll put you over my knee and I'll spank you like a child, but I'll do it with a ton of jail time. Do you understand? The day of you being a child is over. You are now an adult, and you will be treated like an adult. If you play stupid games, you win stupid prizes. All I want you to do is leave better than you came here, and I'll do everything in my power to make it happen.
Sir.
Okay. Can you print me out that list form, please? All right. So I'm going to have you sign a receipt with Victoria. You'll meet with Felicia for all your conditions, and then you're off on your way. We'll roll your court costs so you won't pay.
Is the reset on the 22nd?
Say it again?
The reset 2 weeks on the 22nd?
Yes, how's, no, 2 weeks from today.
Yeah, 2 weeks from today.
Okay, that's
How's December 2nd, just because that's a holiday.
December 2nd-ish.
December 2nd-ish is perfect. Second.
All right, it's yours. Required, yeah. You're going to get tested. Do you understand? Okay.
Mr. Diego, the courts is gonna give you some information with my office.
Hold on, John. He's talking to. Okay, go for it, John.
Diego, the courts should give you some information with my office number. When you leave court,
50.
call that number immediately.
Sir.
I'll get your information, or if the courts give it to me, and I'll reach out to you. I just don't want you to have to say it, while we're talking on Zoom. Okay?
Yes, sir.
All right, I'll talk to you soon then.
All right.
Thank you, Judge.
Thanks, John.
Have a good weekend.
So we did almost all of Friday. Whew. I had fun tonight. I had a lot of fun tonight. Yes, I did. Today, this morning, whatever you want to call whatever it is right now. Because actually, Fozzie, it is tonight in some places. Right, CJ? Right, Rebecca? Right, security? Right, Marty? It's tonight there. So I'm always right when I say tonight. Ah, thanks, Jen. I got it at work. Yep, yep. Big dog. It says big dog. Because believe it or not, usually, like I wear in my normal day life the baggiest things that I can find. The baggiest. I I had to get all new clothing for streaming because baggy. I like baggy. Baggy makes me feel good and warm and comfy. What are we talking about? I missed it. I missed something. All right. I'm going to put my outro on and I'm going to go work a double. And I will see you guys in Bill's or tomorrow or in Judge Fleischer's courtroom next. It's up to you. Thank you so much for coming out, everybody. I really appreciate it. Don't forget to say happy birthday to Victoria in those shorts that I posted because it'll make her feel good. And it's the Victoria, the Victoria. And really, out of everybody that we know, don't make her mad. Just don't. So I will see you guys next time. Thank you so much.
Got these lights that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes mirror sky so blue. In her jokes there's a truth so true. With each string she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm.